Hi, everybody. Welcome to our next installment of the H1B Cap Lottery Series. As we're getting to March 18th, which is our D-Day, our deadline, it's coming very soon. So we thought we'd just reach out and get back into the swing of what we're trying to do, what we're trying to achieve, and just the strategies, the strategies to get going right now, what you need to know, what has changed, what updates have we had since our last installment, and really what can we do to move this process and make it as seamless as possible. So as always, we start with our legal disclaimer. We are lawyers, and everything you hear today is not specific legal advice for specific cases, general information. It's enough so that you know what to ask and how to reach out to us and what to reach out to us about, and how we can really help each other in achieving our goals. But really, it's not a specific information. If you have specific questions, don't take, just like you wouldn't do surgery at home, don't do immigration legal surgery, with your cases as well. Reach out to us. That's what we're here for. We will provide our contact details. Feel free to reach out to us. We're happy to answer any questions. But realize that every case is different, and we should always be concerned that there might be little idiosyncrasies that will change the way certain informational things will be transmitted. So please reach out to us. So that's very important. Just starting with a little bit about our firm. Some of you know about us. Some of you have worked with us before, and we're happy to work with you again. We are a full service immigration law firm, helping corporate clients, helping individuals, helping everybody we can with immigration. If you look on the left side, you'll see some of our accolades. That's probably the least important part of it. We're happy to work with you and to help you and work with you in terms of a high-touch approach, trying to help you, trying to work with you in the most seamless way possible so we can get the best results. We're very proud of our own software. It's called Rapid. This is the next generation immigration software. It's to make us more efficient to help you. It focuses a lot on reports, analytics, data security. Both from our side and on your side, it just makes it easy. It makes it easy really to work, to report, to really just to make this a very complicated system much more simple. Today I have with me my illustrious colleague Miki from our Boston office, our co-managing partner in our Boston office, me, Cliff Rosenthal, from our Los Angeles office. And we hope today to go through as I mentioned in the beginning, the H-1B process, the registration process, getting ready for the CAP, the finale of the CAP season. The CAP season has already started, but getting ready for the finale, the march down, no pun intended, to March 18th. So what we're going to do today is we're going to look at a few things. We're going to look at the updates on the H-1B Cap registration. There have been a few updates. We're going to look at some of the other critical matters, the F-1 onboarding, some of the H-1B lottery issues that come up generally. These are generally the most critical issues. So some of it is a reiteration of what we've done before, but it's certainly critical and very focused and very important. We're going to look at prevailing wage issues, H-1B trends as we get to selection, and hopefully all of our clients are going to be selected, and we are going to have so many, go into the nitty-gritty of the cases, and we want to look at just what can be prepared for on selection and non-selection, etc. So without any further.
Stay for a sec, Cliff.
Yeah.
So we wanted to do really quickly, just a little poll to gauge your level of experience with H-1B so that we can calibrate to what might be helpful for our audience today. So if you can respond to the poll that pops up on your screen. And James, let us know when you have the results.
Sure thing. We've got results coming in now. About 70 people have popped up. I will let you know when we get a few more. So far, the front runner is 35%. I have sponsored employees on H-1B petitions, and I am familiar. Now that's 36%. It's pulling away from number 2, which is my company has H-1B employees, but I'm not very familiar at 34%.
Okay, so great. We have some of a mix, but yep, it seems you're in the right place. This is the place. You know, we're going to talk about the H-1Bs, you know, the sponsorship, the registration, and the all important parts of that.
All right, I'm going to go ahead and end the poll. 38% have sponsored H-1B employees and are familiar. I'll share the results.
Awesome. So we have a gamut. That's helpful. Thanks, everyone.
Okay, so Miki, why don't you just you know, run through a kind of general H-1B timeline? What can everybody expect from a top up level?
Yep. So here's a really quick review of the critical dates you need to know about. You know, it's a table here. You can print it out and have it handy on your bulletin board or whatever you have. So, you know, by now, hopefully, many of you have started your H-1B case with us for the lottery. And the first date to look out here for is February 21st. So that's the date that employers can create the My USCIS accounts online. If you are new to the lottery system, or maybe you are a new contact for H-1B sponsorship. You'll need to create this account in order to enter your employee into the lottery. If you have an account from last year, you don't need to wait until the 21st. You can log in now and check to make sure you have the right password, it's accessible, and all of that. And then one note is if you're a company contact for multiple subsidiaries or affiliated entities under the same umbrella, you'll need to create one account for each of the entities that has a distinct employer ID number. And then when you're creating an account, just a quick tip, this is actually really important. You need to select the account type for I am an H-1B registrant. Don't choose the option for I am an applicant, petitioner, or requester, because if you do, then you'll have to use a different email address to create the proper account. If you have a case initiated with us, you can use your step-by-step guide that we provide, so that we can make sure you're doing it correctly. And if needed, we can also set up a Zoom and a screen share to guide you through as well. And so the next major date here is March 1st. The registration will open at noon and will be open until March 18th at noon as well. And so during that time, our team will be entering the employees that you're sponsoring. We'll enter all the details, and then we'll help you to link our account to your USCIS account. And then you'll have an opportunity to look at the draft registrations before we submit. And it's really important that everything is accurate, because once we submit it, we can't change any of the details.
Yeah, I just wanted to add that, just note that that time is a 12 p.m. Eastern time. So if you're in other parts of the country, if you're like me in Los Angeles, it's going to be you have a much earlier window. So just be aware of that.
Thanks. That's really key. Thanks, Cliff. And then, in terms of the process, then we pay the $10 fee. We assume that by March 18th, the USCIS is going to receive more registrations than there are slots available. And if they do, then they'll run the lottery sometime between March 18th and the 31st. If there aren't enough registrants, they wouldn't need to do a lottery, but we're not expecting that. And then by the 31st of March, the lottery results would be available, and notifications will come into the My USCIS accounts where the registrations will show up as selected. People who aren't selected will show up as submitted. And then, of course, our team will let you know when the results are uploaded to the My USCIS account.
Okay, so going on to the next part of our review. So as we mentioned, the lottery, between 18th and 31st of March. So the way it really works is as follows. What they're trying to do is they're trying to maximize how many applicants with US advanced degrees, master's degrees, and up will actually get selected. So they're trying to increase the chances, and it's part of this, the STEM initiative. It's really about that. And the way they do this as follows is that there's 65,000 in what's called the regular cap. That's for, for all applicants. It doesn't matter, where you got your degree for. You can have experience instead of degree in certain situations. That's what we call the regular cap. And then there's an extra 20,000 slots that it's called the master's cap. But it's really for advanced degrees. It doesn't have to be a master's. For instance, a law degree could be considered a master's or an advanced degree for this purpose. But after they've done all the first 65,000, then they're going to do the second lottery, which is with the 20,000. And that way, many of the advanced degrees will be included in the 65,000. And then there'll be another chance for those not selected in the first one to get into the next one. So that's how they prioritize advanced degrees, and it must be an advanced US degree to get into it. Based on last year, and really the year before as well, is that the way they do it is as follows. If they're always oversubscribed. Now, if I remember correctly, there were around about 300,000 applicants for the last lottery. If you look at the two lotteries together, 65,000, 20,000, roughly 85,000 spots. Not quite that, but so what happens is if they're oversubscribed, which we again expect them to be, they run the lottery, and those selected, you're going to get the privilege. And just note that those people that are selected, it's not that they get the H-1B itself, they get the privilege of filing an H-1B application. And we're going to go a little bit into that, what's involved in that. But those that are not selected will remain on reserve, which means that, doesn't mean they're out yet, doesn't mean it's over yet. But if not enough applications based on selections are received, then they will rerun lotteries until such time as as that happens. And based on last year there were 2 additional lotteries. The previous year was 1 additional lottery. And what tends to happen is that applicants sometimes have more than one application, and they only choose one, or sometimes the job doesn't pan out, or they lose their job. So for whatever reason, for the last 2 years there have been extra lotteries, and these applications, you don't have to re-register, you don't have to, immigration will randomly run the lotteries at various times in the year. And then those that are the winners will can win later on. So, I think that's quite important. Based on all the lotteries for last year, then there were 3 of them, as I mentioned. The total acceptance rate was 43%. So 43% of those that filed and that registered in March actually in the end got it. So that's pretty good. Well, let me just put it this way: it's almost 50%, but it's better than the money lottery. If the money lottery was close to 43%, I'd be entering much more often. Okay, so let's go on to who qualifies for that master's cap, that advanced degree cap. So again, has to be a master's degree or an advanced degree or higher, can be a PhD as well, with an institution of higher education. So for our purposes, and what we have to be very careful is, what is an institution of higher education? And there's a technical definition based on statute, but what's very important and the major issues we see are, is whether the university that grants it is a public or non-profit institution. There are lots of private schools going around, and private non-profit is for sure fine, which is, I guess, most of the main schools, but many of the private for-profits are not, do not qualify for the master's cap, and that's very, very important to realize. Sometimes you can tell by the name, some of them we know, but sometimes you cannot tell by the name, and they seem like a regular university, and you think, well, this person has got a degree from a master's degree, but it's not from an institution of higher education. So that's critical, because if you're selected for if you selected certainly for the master's cap and you don't have the correct degree, your application will be disqualified, and you won't be able to get a master's cap number if that's what you have won. So that's the first point. The second point is, when do you have to have the degree by? So one of the general principles of all immigration law is that whenever you file for a benefit, no matter what it is, you should be qualified for the benefit at the time of filing, not necessarily the adjudication, but the time of filing. So now that we have this bifurcated process where we register first and then we go on to the filing of selection, the question is, what is filing for these purposes? When does the person have to be qualified? So what's very clear now is that the registration is really a registration. It's not a filing, it's not an application. So nobody has to have the qualifications at the time of registration. But if you select it and then you earn the privilege of filing an application, at that point, that's when you have to have the required degree. So if, for instance, as Miki was mentioning, we March 31st, you get selected and you file in the 90-day window, say April 1st, then on April 1st, you're going to have that advanced degree. What's also important is, for immigration purposes, having the degree, being awarded degree, means completing all the requirements for the degree. So if you've completed all the requirements, but you just haven't had the ceremony yet, that's fine. As long as you can get a letter from the registrar of the university to confirm that all the requirements were met. So that's one leniency that's important.
I just want to add to that too, that I think the timing issues are so critical. And if you have anybody who, if you have an employee who isn't absolutely certain whether they're going to complete their program before the June filing window is over, you may want to file that person under the regular cap. And regular cap versus master's cap is something that we do indicate in the registration. So, if you have somebody who is sort of in that in-between situation, you can let us know and we can work with you to figure out the best strategy. And then the next slide is about the proposed process updates. So USCIS proposed some updates to the registration process this year. And the changes are basically, they're published in the Federal Register and they're accepting comments until February 22nd before they finalize these changes in advance of the registration window on March 1st. So I'll just touch upon a few of these. The first one is the feature to prevent duplicate registration. So it's always been the case that a company can enter only one submission per employee. And any duplicate registrations are automatically disqualified. So we always have carefully reviewed to make sure there's no inadvertent duplicates. But USCIS is adding this feature just sort of as a double check to allow you to see if there are any inadvertent duplicates. I think actually, Cliff, do you want to talk about sort of the disqualification?
So this is a feature, and just they are proposed at this point, expected to go through, but they are proposed. But the point, I think that's a very important point, is that this only checks according to the particular entity that's filing the application. So as Miki mentioned, one entity cannot apply for more than one registration for a particular employer. It doesn't matter if the job is different, if there's a business need to have more than one job, one entry per person per entity. But what it doesn't do is relate to a different rule, and that I just want to bring up that is important as well. And it's important to be aware of is that what they also don't want is for the same position to be applied for by multiple entities that are related to each other. And certainly, for instance, if you have a group of companies, a group of subsidiaries, or a group of affiliated companies, they shouldn't be applying for the same position for the same employer. So in the same entity, even different positions are forbidden, But even if different entities in the group for the same position, then that's not permitted as well. And you have to be a little bit careful what some companies want to do. They want to maximize the chances of the person in the lottery. So they may have a group of 5 or 6 companies, and they'll say, well, all 5, 6 companies, we are going to apply for this person. So and then whichever one gets selected, that's what we then that's what will work, and we'll transfer it to the other or some. That according to the regulations is not permitted. And if immigration gets wind of that, then not only will they disqualify the second, they'll disqualify all entries, and the person won't be able to qualify for any entries for that person. So that's what they're trying to stop. They're trying to make it as fair as possible to get for one particular position. It shouldn't be too much. It shouldn't be too many companies filing just to do that. And just to say how far this goes is that there was an adopted decision, which is a precedent decision that was that was adopted by immigration, where they even looked at the term related very, very broadly. This was actually a case where there were 2 vendors that were going to place a particular software engineer at one particular end user, one particular company. We won't go into all of that. That's a whole webinar in itself. But what happened was that these 2 vendors that they had no relation to each other, other than one was a contractor and one was a subcontractor. And I guess that was the bad, they say bad facts generally make bad law. But these companies weren't related at all, even though the regulations say related companies cannot file for more than one. But immigration found that for the purposes of this rule, anything that's really the same position and some loose relationship is going to be sufficient. It even seemed that even if they weren't related at all, they didn't have the subcontractor relationship, that would have been enough. So it's possible that 2 vendors that don't know each other applying for the same position could get everybody disqualified. So it's very important to look at this tool that as I mentioned, this tool that they're going to use to check will only check in the specific company, won't look for related companies. And then just be very careful as well. Things, registrations that are in process that have not been finalized. That they're not going to come up either. So it's a tool, but it doesn't alleviate us from our task in order to check very carefully as well.
Yeah, and along those lines, down to the 4th bullet, skipping ahead to the 4th bullet here. The USCIS is also proposing adding this attestation as part of the registration for the employer to basically say that this is a legitimate job offer that you're entering for the lottery, and that the company hasn't worked with another company to submit multiple registrations for the same employee. So similar, I guess, two prongs, to get at the same result.
Yeah. So just be very careful. That's what you're signing. So if you know that you're working with a whole bunch of other subsidiaries to have multiple filings for that person, and it's the same position, be aware it's putting everything at risk.
Yeah, interesting though that neither of these features really addresses the situation where one person shops around to many different employers and gets offers from different distinct companies, each of which, the unrelated entities enters the same person separately in the lottery. But in any case, so on to the next feature or the proposed update. It's a clarification about payments. So USCIS accepts the $10 registration fee by credit card. And if the payment is declined or disputed, then the entry will be considered invalid. So, at our firm, we contact the credit card company ahead of time to make sure that they're anticipating all of these multiple $10 charges and to flag it for them so that they don't, they don't think that they're fraudulent charges. if you're working with our firm, you don't have to worry, we'll take care of that. But if you're doing this on your own, I recommend giving your credit card company a heads up, because if the payment doesn't go through, your registration is not valid.
Right, and if they see a whole bunch of $10 bills to the same place over and over, they may think that's fraudulent to begin with.
Exactly. And then the last main feature update is the warning upon withdrawing a G20. This is really, you know, an update that if you are trying to delete a duplicate entry, you know, you find that you had an inadvertent duplicate entry and you want to go and withdraw one. I guess it can be confusing for some people that withdrawing the G28 does not delete the registration. So just be careful about that.
Right, so it goes back to what we were just discussing. If you withdraw the G28, the representation form, and the actual entry is still valid, and then you go and make it, and you know you don't realize that, you go make another entry, you're going to have that double entry problem again. So that's important to note as well. Okay, let's go on to F1 onboarding and and a little bit more deeper into the H1B, you know, lottery mechanics. Miki, why don't you take us, you know, a little bit deeper into the H1B registration process?
Yep.
What happens?
Yep, exactly. So this is basically just a flow chart that you can keep handy to see how it flows through the life cycle up until registration. So first, you know, we initiate the case, we get what we need from you and your employee, then we assess the case so that we have an opportunity to flag for you any issues that we see that you need to know about. It can be, you know, for example, this H1B is going to be really aggressive, so that you're aware before you go into it. And then the registration that I talked about earlier with the key dates. And then the lottery results will come out, as I said, March 31st, and we'll let you know of the selected cases. And I wanted to highlight for you here in the middle, there's a bubble for LCA, that's labor condition application. The LCA isn't a prerequisite to the lottery registration. It's just, you know, it's basically a document that we would need to file with the H-1B petition once it's selected. But we do recommend that we prepare the LCA ahead of time before the registration so that, you know, basically doing the LCA for us, it fleshes out any case issues that wouldn't come up until we actually do the LCA. It'll help you to kind of stay ahead of any problems and to manage expectations for your employee if there's anything that needs to be addressed. If we can go to the next slide.
Okay, and after selection, what happens then?
Yep, so basically after the case is selected, we'll build on the LCA that was prepared before, and we'll prepare the remainder of the case. We'll get the signatures from you and then file the petition with the USCIS within that 90-day window between April 1st and June 30th. Once the receipt notice is issued, obviously we'll send it along to you. And we'll be monitoring the case, but if you and the employee want to monitor, you can do that as well. And then in terms of the decision, when does that come in? USCIS adjudicates H1s, you know, anywhere between 4 and 6 months at this point in time, and that can fluctuate. If you use the expedited adjudication, which is called premium processing, you'll get a decision within about 2 weeks of a certain date that USCIS says, you know, here's the start for the clock for the 2-week window for receiving a result. So after the 2 weeks or the 6 months, you basically get an update from the government, which will be either an approval or request for evidence. And we'll talk about RFEs more later in a little bit more detail, but basically the request for evidence means that the government wants additional information or documents in order to approve the case. And so if there is a request for evidence, then it'll take an additional few weeks to a few months for the decision to come through.
Okay. So another hot topic, and this, you know, this happens, you know, every year is what happens with the F1 to H1B. I mean, what typically happens is you have, and the flow chart really shows this, you have an employee who's working on OPT, that's the the work training visa that comes with the F1 student status. So let's say they get selected, they've got to file the application somewhere between April 1st to June 30th. Let's go with 2022. And then the OPT ends sometime after the filing, but before September 30th, when the H-1B starts. So what happens is it's a fiscal year for H-1Bs, and it goes from October to October. So even though we get a 6-month almost grace period where we can file for the H-1Bs before they start, any cap related H-1B, the first date for starting the actual H-1B cannot be before October 1st, because that's the first day of the new fiscal year for all immigration petitions, including H-1B. So what happens if you've filed the H-1B, but it's still pending? But while it's still pending and you've been selected, you filed it, but the OPT ends before October 1st. So what happens? You lose your status. So the rule is, if the OPT expires after H-1B is filed and it's pending, you have what's called cap gap relief. What will happen is that the time gap between when the OPT ends and the H-1B starts on October 1st, that gap is being closed. And what effectively happens is immigration will agree to extend that OPT until September 30th. So that's a great situation for everybody. But what happens if the OPT ends before? In other words, in this case, if the OPT expires before the H-1B filing window, the person has to stop working, but they can actually remain in the United States as long as they file within the 60-day grace period. So all OPTs get a 60-day grace period where people can file other statuses or pack up and leave. So if you're within that 60 days grace period, when you file that H-1B pursuant to a selection, the rules are a little bit different. There's no cap gap per se in terms of work authorization. The person has to stop working, but they can remain in the United States. They don't have to leave. So that's the different scenario. Cap gap is triggered based on filing. It's not based on registration. So for instance, if you're selected in the lottery and let's say your OPT is going to expire, let's say April 15th, you really want to get filed. You don't want to wait that full 90 days to file that H-1B selection, even though you got those 90 days. And in order to get the cap gap, you're going to have to file before that OPT expires in order to get that selection. And then if you're not selected, that's the time to again reach out to your WR attorney and look at other options. Just one final point in the bubble that I just want to mention is that cap gap only lasts until September the 30th. So on October the 1st, the new H-1B will become valid, hopefully, and it will supersede the cap gap. But what sometimes happens if there's a request for evidence, or sometimes if there's a second or third lottery that's just before September 30th, the question becomes, what happens on October 1st if the H-1B is still pending then? So then it seems, that at that point, that's a tough situation because there's no longer cap gap, and the person would have to, end their employment or stop working, and at that point, look at other options, maybe premium processing, maybe expedite, and see what we can do to get that H-1B completed as quickly as possible to minimize any gap. I just wanted to mention this is one of the changes that the government has proposed in terms of the STEM initiative. I believe last week or the week before, there was a STEM initiative that was announced by the Biden administration. One of there were a couple of different initiatives to try to encourage STEM degree holders, students that have got STEM degrees in the United States to remain in the United States. I think the one that really concerns us is that there were addition of 22 new fields, which means that for those that are not selected, they're going to get they could get the benefit if they meet certain other eligibility qualifications, that they can get an extra 24 months of OPT, and that would give them more of a chance to, to stay in the United States and get extra time in that. I'm not going to read through, all 22 new fields, but I think the important ones are, some of the new fields, that, since the STEM OPT has was instituted, that addition, data science and data analytics is something that's obviously very big, and those are kind of the major additions. But you can look at the different fields yourself. Let's go on to another topic that I think is also very important when it comes to actually filing the applications, and those are what we call prevailing wage issues. Miki, why didn't you just discuss a little bit about what are employers' obligations, where do they get their wage, what is the minimum wage, how can we help?
Absolutely. So it's important to know that when you file an H-1B, you're signing on to some wage obligations as an employer. These wage obligations are part of the labor condition application that I mentioned earlier. And the employer basically needs to pay the H-1B employee a wage that meets or exceeds the actual wage or prevailing wage, whichever is higher. And this obligation kicks in as of October 1st. So what's the actual wage? That is whatever you're paying other employees in similar roles with similar credentials at the same office location. So that's company specific. It's what you're paying other employees. And that's really basically to ensure that you're not undercutting U.S. workers' wages by paying an H-1B worker a lower wage. And then there's the prevailing wage. And where do we get that number, the prevailing wage? That is based on three possible sources. The first go-to for us, unless it's a union organized role, is the Department of Labor's own database. It's called the OES. And it's basically a wage that's set for the occupation in the metropolitan area. And they refresh the database every July 1st. And the occupations, we go into the database, we look at the occupations that are the best match, and they are broken down into levels based on educational and experience requirements for the role. Sometimes the Department of Labor's prevailing wage is above what the employer is able to pay. And in that case, we can explore for you private wage surveys, which we do pretty often. And they frequently yield lower wages. So we work with an outside vendor who specializes in wage surveys, and we identify possible options. And when we review those options, we are always making sure that the survey data will pass muster and would be accepted by the Department of Labor and USCIS. They basically have certain requirements for what the private wage surveys have to meet. And so we're vetting the survey and, making sure that it would be successful when the H-1B is adjudicated. H-1 adjudications. Okay, here we go. You can scroll to the next one. Okay, so here we want to let you know about what the current climate looks like. And based on what we've seen in the past, what you should be aware of going forward for this season. And just by way of context, under the previous administration, denials were at an all-time high, right? And new H-1B filings were being denied at about 20% or maybe a little bit higher than that. Under this current administration, the landscape looks much better for us. New H-1 denials are at about 4% at this point in time. So it's more favorable to H-1Bs. So here we've listed some of the common bases for RFEs. And the first one up is the most common, it's specialty occupation. And what that means is that, USCIS, when they issue an RFE for specialty occupation, they want to verify that the role is one for which at least a bachelor's degree is required in specific fields that are very closely related to the job. And so, for example, the classic example would be software engineer position has to require at least a bachelor's degree in computer science or related fields, right? And so if you have a role that requires a bachelor's degree in computer science, but you're always also hiring people who have liberal arts degrees, then that's something that could be a challenge for proving that that occupation is a specialty occupation. This is kind of the classic RFE and the most common one. We have strategies in place that we can discuss with you if it's not a clear-cut case. And the success basically will depend on, how complex the job is in terms of the job duties, and if the job requires application of theoretical knowledge gained in the fields of study that are closely related, and looking at the company's hiring practices. The next common one is the appropriate job code. So, the database that I was talking about earlier has job codes, and it's based on occupation. And USCIS will look at that to see if the code supports specialty occupation. But also they want to make sure that the LCA supports the H-1B petition and that it's for the right occupation. So, they might issue an RFE that challenges, why did you choose that particular occupation? And you might have to defend it by showing how closely the role is related to what the Department of Labor's code is. Another one we see is the appropriate prevailing wage source. That's what I mentioned a little bit earlier about making sure that, we meet the requirements, or the private wage survey meets the requirements of the USCIS and the DOL. Maintenance of status is another one. In order for the employee to change status from, for example, F1 to H1B from within the United States, they have to show that they were maintaining valid non-immigrant status throughout. So that means that if they were on OPT, they need to make sure that they didn't violate their F1 status. And one thing that has cropped up in past years is the RFE on the CPT. So what CPT is, it's curricular practical training. And people who did not get selected in previous H1B lotteries and they ran out of F1 OPT time, some people have gone back to school to re-enroll and get back in F1 status. And in some cases, people can continue working for that same employer by gaining curricular practical training called CPT. And we call that day one CPT if it's a graduate degree program that allows for people to continue working for that employer. Normally, there's the requirement that you have to attend school for a certain period of time before you're eligible for CPT. But for certain master's degree programs and at certain schools, they'll allow you to kind of skip that preliminary period and go right into the employment or practical training. And the previous administration scrutinized that a little bit, and they were asking, they were issuing a lot of RFEs on that point to verify that the individual who was on the F1 CPT did maintain valid status and that they could produce the documentation to show that they were actually attending school. And that it wasn't just a workaround to circumvent immigration laws and that, the CPT is a sham. They have to show that they were actually attending school and they were progressing towards the degree. And so that's another common one that we have seen. And then finally, the last one is the availability of specialty occupation work. And that's really one where USCIS wants to make sure that the H-1B employer has enough work available for that H-1B sponsored employee that is qualifying work. They sometimes want to make sure that, the employer is not going to bench the employee, or that if they run out of work, that the H-1B employee, would not be doing clerical or administrative work. Or anything that falls outside of the scope of the H-1B role. So sometimes we have seen that in the past. It remains to be seen if those RFE bases, aside from the specialty occupation, will be common this year. I see that Cliff is back. Welcome back. Hope you got your power back.
I got my power back. I apologize, everybody. I know we want to leave some time for questions, and we will. I just want to remind me of a funny story when I was in college that I just mentioned to you. Is that it was a statistics course, and it was this. We had a little bit of essay, a professor that was a little crazy. And what he used to do at the last lecture of the course is everybody used to come in expecting the last lecture to be, fun and, we're going to end off on a great note. So what happens is this professor runs into the classroom and he's looking around and he's hiding behind all the chairs and looking here and looking there. And then, he arranged it with these two big people come with these white coats and they run into the lecture room and they manhandle him out and they take him away and he's kicking and he's screaming and, that's the end of the course. And you never hear from him again. So this is kind of what it reminded me of. I'm not leaving you in the lurch, and I'm happy to be back. I just had a temporary power problem. And thank you for Miki for stepping in onto some of the slides that I was supposed to do.
No problem. And James is controlling the slides now. I don't know if you want to step back in, but I know we have a couple more slides, but maybe we should switch, Cliff, to questions. I see a bunch of questions in the Q&A.
Yeah, there seems some questions, so let's go to that.
All right. Let's see. Oh, there was one question related to what was the percentage of selection that you mentioned earlier, and that was 43% from last year. And it's hard to say what it's going to be this year because, really depends on the demand for an H-1B number. But, from last year, it was about 43%. The next question is, let's see. Here's a quick one. Does premium processing take 15 business days or calendar days? And it is 15 calendar days. I know there was a proposal to update it to 15 business days, but that did not take effect. So it is 15 calendar days for premium processing. Cliff, I'll pose this one to you. Someone asked, can an LCA be submitted prior to April 1st? Or is April 1st the earliest date to file? For example, if OPT expires in early April, if I can only file LCA by April 1st, the timeline to file before OPT expiration will be very tight. Any solutions for this problem?
Yeah, it's a common problem. You can only file an LCA labor condition application 6 months before the start date, and if the start date is the earliest start date on H1B, because the fiscal year is October 1st, that really means that on April 1st would be the first time that you could file. But there's a way to do it. What you do, you can file earlier, but what it will mean is that the LCA start date will be before October 1st, which is not a problem in itself. The only thing is that your end date is going to be less than 3 years. So the maximum of the H1B period, a maximum period is 3 years. And, and usually you would want it to get the maximum to go from October 1st, say 2022 to September 30th, 2025. So if you do that labor condition application first, that's fine, and you can do it first, and it's a way to deal with the anxiety. But you'll know however much you chop off in the front, you're going to chop off at the back. So if you file it on March 1st, then your H1B at the end will be it will be 1 month shorter. And for most people I would say do that. It's really worth the less anxiety than waiting till April 1st.
Here's another one. Does the timing of when the OPT expires during the lottery affect the type of filing if selected and they aren't eligible for STEM OPT? For example, change of status versus consular notification.
Yeah, so essentially, you always have well, let's just explain what's the difference between change of status and consular processing first. So change of status means that you're in one particular status now, and with your application, immigration will automatically change your status to the status that you're wanting. So if you're an F1 OPT now, change of status would automatically change your status to H1B without you having to leave the country and activating it by leaving the country. Consular processes means we're not worried about what your status is now. we worried, we just worried about what you're changing to. And the reason we're not worried what your status is in now, you don't have to show that you're maintaining status, which you have to do for a change of status, because the way you do it with consular processing is you go abroad, you get the visa activated by coming. And if there are any violations, whatever, they'll be dealt with by the consulate. So if you have status until October 1st, and that may includes cap gap as we discussed earlier, then that would really be sufficient for change of status, and that's kind of the preference that most people will do. If your status is, if your OPT, for instance, chops off earlier, in other words, it's before usually before April 1st, your OPT expires, then you can still file the application, but you would have to do it for what's called consular processing. You'd have to go abroad, get the visa, and you would only be able to come back 10 days before your start date, which would be before October 1st.
Great. Here's another question. For TN visa holders, does cap gap apply? It does not. Cap gap is only for F1 students. And the follow-up question is, if you're wanting to transition from a TN to H1B, is it best to start the process during year 2 or 3 of the period to give a second chance? Yeah, I mean, if you have the intention to switch over to H1B, or you want to switch your employee to H1B, it's always better to start earlier rather than later. Particularly, I guess for TNs you can extend, but for F1s where there's a finite period, it's always better to start earlier in the lottery process, because again, the lottery selection chances of selection are not that high. Let's see, I think there was a question earlier about, do foreign degrees qualify for master's cap? And the answer to that is no. It has to be a master's from a U.S. institution of higher education. Let's see. What is a best practice when attracting talent and they do not meet the minimum requirements as needed to sponsor an H-1B visa? Cliff, do you want to take that one?
Right. So, I mean, the H-1B has specific requirements and specific eligibility requirements. So it does happen to be your standard, I would say your standard professional visa. But there are other options that, don't require, such rigorous or maybe different types of eligibility. So, there's a whole gambit, the whole alphabet soup of different types of visas, going from A till, there's a proposal to make a W. So that's kind of in Congress. We'll see where that goes. At this point, you have to meet the requirements, and if not, then we have to look at different visas and see where the person will qualify.
Great. Another question in the Q&A box: can an H-1B worker who works from home that's in a different state where the company is based, is that okay? So, yeah, I mean, there's so many people are working remotely from their home, and it can be outside of the metropolitan area where the company is based. That does need to be reflected in the H-1B petition. So please do work with your employee to make sure that you have, you're aware of exactly where your employee is based and working. And this can also, become an issue where in COVID, people are visiting their families maybe halfway across the country, and they want to work from there. That would be a material change in the H-1B. So once it's approved, you would have to file an amendment potentially. So that needs to be looked at.
Yeah, I think that's a very important point. One of the new issues that we have to deal with, certainly with remote workers, is that the person's home address has now become their work address. In the old days, the person, if they didn't so much update their home address, it wasn't such a big issue, simply because they kept their work address, and that was pretty stable. It's stable now. People are moving around quite a lot, and you have to really be, you have to really know, and you have to know in advance, because as Miki mentioned, if you change location in certain locations, if it's not within commuting distance of the application on your petition, then you have to file amendments, and employers need to be aware of that.
There's a couple of questions that are coming through related to employees wanting to register for the lottery, and this is really, really a critical point. the employer has to be the one to enter an employee into the registration. You know, it's the company's account. The sponsor has to do that. And, you know, if you try to, if the employee tries to register themselves, that could be, you know, really detrimental. So please don't try to do that. And I think for employers, it's important to communicate that to your employee population, to reiterate that as well. And, you know, that's something that's in our guidance as well to the employees. Here's a good one. I heard the lottery cap does not apply to not-for-profits. Is that true? Cliff, do you want to answer that?
Yeah, that's very important. And the truth is it's somewhere in the middle. So, you know, certain nonprofits are what's called cap exempt, which means that they are not allowed to apply in the cap. Usually they don't need to because they're cap exempt, but not all nonprofits are cap exempt. There are two types of nonprofits that are cap exempt. Number one is a nonprofit government organization, and number two is a nonprofit research organization. So if you're a nonprofit, but you don't do research, and there's some specific requirements for how much research and what type of research, and you're not a government organization, then you go into the cap.
Thanks. Is there a cap for applicants of certain nationalities? And the answer is no. There are numerical limitations for green card processes, but not for the H-1B.
Right. There are certain carve-outs though. The carve-outs for the Chileans and the Singaporeans. There's what's called the H-1B one. It's really a different type of visa. They have their own cap that have never been met because there are not enough applicants. And then there's the E3 for Australians as well. There's a carve-out as well for all of those. But those are really, you know, they're very different. Technically, there could be there is a cap, but there's no lottery because they're not they never meet the requirements.
Great. How much of these rules, I think speaking to lottery rules, apply to H-1B renewals? And the answer to that is that H-1 extensions are not subject to the lottery again. So if you have already gotten an H-1B in the last 6 years, then you can you would be exempt from the lottery.
Yeah, and it happens from time to time. You'll have people, for instance, that will you know, they'll get an H-1B and they'll be on even a few months. They'll go home for 5, 6, 10 years, and you know, technically they don't have to reapply for the lottery. They find a new employer and they've never used up their 6 years of H-1B and they've been selected once. You know, they're cap exempt, and you know sometimes, you know, that slips through the cracks, but it's an important exemption that comes up from time to time.
Let's see, I'm trying to look for questions that might address a lot of people's questions. So let's see. Do we have an estimate on the number of applications this year? I don't really know what the estimate is. I think, you know, it's expected that it may be more than last year, with the economy being the way that it is. So, you know, that probably means that selection rates will dip a little before 43%, but I wish I had a crystal ball.
Yeah, wish I did too.
Let's see. Can you elaborate on what kind of CPT issues there could be as it relates to maintenance of status? Yeah, so if people are in CPT, USCIS, you know, a few years back, or the last administration wanted to know if, you know, the company could provide evidence that the individual was actually attending school and progressing in the program of study. I think that was really to make sure that the program was valid and that it wasn't a situation where the employee was paying money to the school just to get that I-20 and continue work authorization where they really weren't attending school. So that goes to showing the maintenance of status.
Yeah, I mean, essentially CPT is it's really supposed to be part of the program. And what some people did when they weren't selected in the lottery, they got CPT and they got a very long CPT, and it could be a CPT for a year, maybe even longer. and immigration became concerned. Was this really training, or was this really just a way to circumvent the H1B cap for people that weren't selected? So that's kind of where the issues stemmed from.
There's a request to talk briefly about the roles that are scrutinized. I think maybe just in the last minute or so that we have remaining, maybe we can touch upon that, Cliff. What do you think?
So, sorry, can you repeat that? I couldn't hear.
Oh, sorry. So there's a request to briefly talk about the roles that are scrutinized. The one that we had to skip over to go to the questions, I think it's
the positions that were scrutinized.
Yes. Yep.
Yeah, I mean, essentially, I apologize again for missing a bit, but essentially what happens is that there are requirements for eligibility requirements for H1Bs, and it's what's called specialty occupation, really. And that really means that the position must require a bachelor's degree or higher in a specific specialty. So for instance, certain positions, lawyers, doctors, it's just impossible to get into these positions without at least a bachelor's degree or higher. On the other extreme, if you have a taxi driver, if the person has a PhD, need a PhD to be a taxi driver. And those are kind of the two extremes. And then in the middle, you've just got a whole bunch of, different types of positions. So for instance, a software engineer, technically it's not like a lawyer, people can be self-taught and become software engineers. You don't really need a degree in computer science, but I would say most people do. In fact, or a lot of people do. So these kind of positions that are in between. I mean, generally software engineers, it's almost assumed now, but there, certain positions that are somewhere in between on that spectrum, immigration is going to want to know is, does this position really require a bachelor's degree in a specific field? And they're going to ask for all different things, including, what are the employer's requirements, and what employment requirements, what others in the industry do, and those are the kind of scrutiny that we kind of look at and see, with these positions. So some of the positions, especially if the employer has a long legacy of applying for these positions and getting approved and requiring bachelor's degrees in a specific field, then they've got that legacy. But sometimes we have more scrutiny on these type of positions. Marketing people, a lot of litigation over marketing analysts, do they require degrees or not? And that's something we look into and advise on.
Market research analyst was one that was litigated, and immigration came back, after denying many market research analyst cases, they came back and agreed that it can be a specialty occupation, where before they just would flat out deny them. I don't think there's guidance that has been published yet, specifically from USCIS on this post the litigation. But I can also call out some of the other roles that tend to be, scrutinized, at least in the past. Computer systems analyst is one that was having challenges for a few years. I think, at our firm, there were occasions where we didn't really have any other option, and we decided to use it. But we were successful gathering up, so long as the evidence is there, it can be winnable. Computer programmers also, as distinct from software developers or software engineers, computer programmers can be a little bit tougher too. In the previous administration, they came out and said programmers are not eligible for H-1B, and that's been softened, but I think it can still be tough. Let's see, some of the other ones, I think under the previous administration, anything with an analyst in the title was scrutinized. I think now probably a little bit different landscape. And then IT project managers, I think we were getting a lot of RFPs on as well. But again, it's really, success is based on what you can present for the specifics of the job and the duties, connecting it to the theories in the degree program, and what kind of evidence, exactly like Cliff said, what kind of evidence can the company present related to the hiring practices? So it all really relates back to, what can the company document? So I think we are out of time, and we went a little bit over. I hope everybody found this helpful, and thank you so much for joining.
Yeah, thank you for joining. We've got our contact details. If anybody has questions, we encourage you to reach out to us. We're happy to answer any questions the best we can. So let's kick off the H1B season now in earnest, and we look forward to to speaking with most of you.
Thank you both, Cliff and Miki. I see that we have a lot of questions that we weren't able to quite get to. Would you mind if I sent them over to you afterwards, and maybe you guys could follow up with anyone who left their name as time allows?
We'd be happy to do so.
Okay, great. So everyone, if you didn't get your question answered, we'll try and follow up. Thank you so much.
Thank you, everyone.
Bye-bye.